good morning and good afternoon, depending on where you're signing in from today. On behalf of myself, Blake and Jay, we thank you for being here and appreciate you putting education as a top priority for yourself to be the best you can be for you and for your clients. Before we start today, we're going to do a couple of housekeeping items. One, like Blake mentioned, please keep yourself on mute unless you want to participate in the discussion or ask a question. There'll be two ways to ask questions. One, if you go to the bottom of the Zoom screen, you'll see a reaction button, and there's a raise hand option. If you'd like to ask a question, please raise your hand. If you're not comfortable asking your question live to the group, you can put it in the chat box, and I'd be more than happy to read it to the speaker on your behalf. I will be doing that, and Jay will be the one facilitating the raised hand comments during the session, and questions will be asked after each speaker. So with that being said, I'm going to pass the floor over to Jay.
Thank you, Linz, and thanks to everyone who signed up and joined us today. So the three of us have been working on this for months, and we hope the outcome that you're going to have from our following guests will be that you have more knowledge and advice to help your clients who have virtual employees. You will hopefully recognize when your clients are getting themselves into trouble, and you may also come across situations where you may realize that through their actions, they've made their employees ineligible to be on the benefit plan, or the reverse, you may find that they have employees who should be on the benefit plan. To help us today, we've got three specialists. We have Doug Suley, Lisa Archer, and Matthew Wise. I also want to thank Toby Pettit from My Friendly Lawyer, as he was instrumental in helping to find Matthew, who will help us later this morning. So our first guest today is Doug Suley. Doug is the owner and lead consultant for Suley Safety Services based in Grimsby, Ontario. Suley's been in business since 2015. Suley Safety Services is an occupational health and safety consulting and training services that assists small to medium-sized business with health and safety requirements. Suley Safety Services works to help their clients achieve compliance, avoid fines and orders for non-compliance, and to prevent work-related accidents. Suley's belief is prevent, not react. By the way, not as just an aside, this isn't from his bio. This is like reading She Sells by the Seashore. Anyways, safety is a passion for Doug. With more than 15 years in the occupational health and safety field in various industries, Suley Safety Services provides clients the tools to achieve workplace safety and compliance. Thank you for joining us today, Doug. The floor is now yours.
Thank you for having me. Good morning, everyone, or I guess it's good afternoon now. Obviously depends where it is that you are located today. I'm just going to share my screen.
So thanks for setting me up with that tongue twister.
You're welcome.
Safety Services.
Can everybody see that?
Yep.
Okay, great. Okay, so today I wanted to take a few minutes just to kind of talk about some of the health and safety considerations when it comes to virtual workers. There are a lot of questions that have actually come up with this over the last couple of years, and it's been really difficult to kind of get too many answers because not only are clients asking myself questions about this, I'm asking the government questions like this, and the government, I think, is still asking questions themselves. So we do have some information available, so I wanted to take a few minutes just to kind of share that with you today. So let me see. There we go. So in a lot of cases, the new normal has become working from home. The new working from home economy has also brought forth new health and safety challenges for employers.
Yeah, this is an M1 for
whoever that is, could you mute, please? Thank you. There are some health and safety issues that come up with this. This includes, will the employer or the health and safety committee, for example, have access to the house for health and safety inspections? The workplace is required to be inspected once a month. Or will alternative arrangements be made, such as employees using a checklist and actually doing the inspection themselves, providing photos and videos as proof to show that their work area that they are working in is actually safe? What parts of the house will be considered the workplace? Is the bathroom and kitchen included? Is it the living room? Is it the area, just the area that they're working in? I have heard in the past of issues where someone was working and coming down the stairs and has been hurt. And unfortunately, because they were on work time, it actually fell into the worker requirements when it comes to WSIB and WCB. What the employee must immediately report any incident or injury to their supervisor, just as they would on site. But how will these incidents be investigated? You know, there is a privacy concern when it comes to working at home that has to be attended to as well. So in many jurisdictions, employers should understand that an employee's home may be considered an extension of the workplace if the home is where the employee is engaged in work on work time. The requirements and duties that are set out in the Health and Safety Acts in each province and jurisdiction may apply, including the General Duty Clause. The General Duty Clause is that every employer must do everything reasonable under the circumstances to protect the health and safety of the worker. This has definitely changed, and it's become a challenge with workers working from home as well. In other jurisdictions like Ontario, for example, this is a little less clear. Unfortunately, they haven't come out with a whole lot of information on this. The definition of a workplace is broad enough to cover a worker working at home, but the Health and Safety Act itself states it does not apply to work performed by the owner, occupant, or their servant in or about a private residence. To make matters more complicated, there's limited case law interpreting this exemption and no meaningful guidance from the regulators. So even if the Health and Safety Act does not apply, it may be best to take a risk management approach to health and safety to ensure workers are not exposed to uncontrolled hazards while they are working at home. So with regards to WSIB, this does come into play when it comes to employee benefits if a worker is hurt in the workplace. So one question to ask is working from home the same as working remotely? So WSIB would consider this to include both temporary and permanent arrangements where an employer directs or allows employees to perform their usual job duties at an approved location away from the regular workplace, such as working from home or another location off-site. How about I am working from home? If I get injured, am I covered? So the employer and yourself have the same rights and responsibilities in the event of a workplace injury or illness, whether you're working from home or off-site or in your regular workplace. Employees must tell the employer if they're injured and it is work-related. The employee says they've been injured while working from home. Does an employer need to report this to the WSIB? The answer is they have the same responsibilities for employees in the workplace and work from home if it is deemed to be actual work. If your employee tells you they were injured while working from home or off-site and requires medical treatment beyond first aid, you must report this to WSIB. You must also report the injury if the employee didn't require medical treatment but was absent from work, earned less than regular pay, or required modified work at regular pay for more than 7 days. If you're not sure if any injury is work-related, you should report it. I've always told all of my clients this, that if anything happens when it has to do with work or someone comes in, it's always best to err on the side of caution. WCB and WSIB will actually go and investigate this to determine whether it is in fact a work-related injury. If it's found that it's not, then there is no harm in you actually reporting it. The harm is more if you actually don't report it and it ends up being a workplace-related injury. My employee is a resident of Ontario and usually works at our regular workplace, but I've allowed them to work remotely outside of Ontario. If they are injured while working, are they covered? An employee who usually resides and works in Ontario but is temporarily working remotely outside of Ontario is automatically covered for up to 6 months of work-related injuries and illnesses. If the coverage is required beyond 6 months, there are extensions that you can actually request for a period of up to 3 years. My business is located in Ontario. but my employee is permanently relocated outside of Ontario, maybe in the Bahamas or somewhere in the States or somewhere very warm, which would be great in the wintertime. But I've allowed them to work remotely. If they are injured while working outside of Ontario, are they covered? So an employee who usually resides and works in Ontario, but is temporarily working remotely outside of Ontario is automatically covered. Non-resident employees who are indefinitely working remotely from a location outside of Ontario, though, including those who work from home, are not covered by WSIB. If my employee was injured while working from home or working remotely, how does the WSIB determine whether they're eligible for benefits? It would be the same way that they actually determine eligibility for benefits when they are working in the workplace in Ontario. A designated home space, workspace that is approved by the employer, and an agreement and a setup that is set up so that the workers are actually working from home and it is approved, they would be determined to actually be working on company time. And if an injury were to occur during this period, they would actually be required to pay claim, and the employer would be required to claim in these cases. So to kind of go back to my previous point about due diligence, employers really do need to consider reasonable steps to ensure the health and safety of their workers that work from home in any type of jurisdiction that you're in. The health and safety laws put the onus on the employers to do everything reasonable to protect their workers. Because of this, that can actually be left up to interpretation in some cases. You're always better off, and I always say, to err on the side of caution when it comes to this. Reasonable steps that can be taken may include implementing a work from home policy and program, or providing workers with information and instruction on setting up their home office to ensure that it is set up safely. One way to do this is to actually develop a work from home or telecommuting safety checklist for workers to use to assess their workspace and forward a copy to their manager. Any hazards or concerns that are identified during the assessment should be discussed with the worker's supervisor so that measures to control these hazards can be implemented. The reason for this is a supervisor has the responsibility to make sure that their workers are working safely, and also that they correct any hazardous condition that arises that they are aware of. This does also include when a worker is working from home. Some ergonomic conditions, try to avoid working from couches or other soft surfaces that do not have a stable work surface or lack support for your back. I'm guilty of this as well. I love to sit on my couch and put my feet up with my laptop in my lap and work away, but I definitely feel it after a few hours of doing that in the rare instances I do get to work from home. Position your computer so that the windows are beside you, not in front or behind you. Using blinds and curtains to control glare and will reduce the risk of eye strain. Make sure that you follow good housekeeping practices. Keep your area clean. Whether you're in the workplace or whether you're at home, you do need to keep your work area clean. It is a requirement. Get up and move around periodically. Frequent very short breaks throughout the day are important for both physical and mental health. Adjust your chair for all features to support your back, thighs, and be at a comfortable height. If you do not have an adjustable chair, use a folded towels or a cushion as needed for extra padding and back support. Position your monitor or laptop screen approximately arm's length away from you. And use a footrest or a box or something sturdy to support your feet. Not all of us, everybody is all different heights, and everybody has different lengths in regards to their legs. So sometimes with certain chairs, if someone can't even put their feet to the ground, then setting up a footrest definitely helps to allow them to have proper posture while they're sitting. And this does apply whether you are working in the office or working at home. When it comes to incident reporting, it's important to make sure that you develop and implement a reporting protocol to address all incidents that occur when a worker is working from home. Workers should receive instruction to immediately report to their manager any incident or other occurrence arising in the course of or in connection with their work that has caused or likely to cause an injury. Depending on the jurisdiction, employers should investigate these incidents and, if necessary, notify the Joint Health and Safety Committee if there is one in the workplace. Some workplaces are smaller than 20 employees, so in these cases, they will have a health and safety representative. The health and safety representative has the same powers and responsibilities that a Joint Health and Safety Committee will have in the workplace. So if a Joint Health and Safety Committee is not present, you would report it to a health and safety representative. And depending on the nature of the incident, whether it's a serious injury or even a critical injury, external parties may also need to be notified, such as an OHS or health and safety regulator. In Ontario, we have the Ministry of Labour. In BC, you would have WorkSafe BC. Or it could also be workers' compensation. So WCB, it could be WSIB for those of us in Ontario. So it's important to make sure that those reporting requirements are still met, and any critical injury or fatality must be reported within 48 hours of the incident occurring. Did we go too far? No. So what would go into an agreement? Teleworking agreements are something that can be set up between employers and employees. This helps determine whether an area is specific to the workplace for a worker while they're working at home. You should consider the exact location and contact details for where that employee will be working from and have them recorded in case of an emergency. You should consider a statement that requires the employee to follow all company health and safety policies when establishing and working in a remote or home office area. Travel for business meetings or at home. You have to consider this as well. Travel requirements for safety, reminding your workers whether they're in the office and travel for work or whether they're work from home and traveling from there. You have to remind them as an employer, no speeding. Make sure you wear your seatbelts. These are all things that seem very common and trivial, but unfortunately, the employer has the onus to make sure that they remind their workers if they are traveling on work purposes. Not only can this affect insurance, but it can also end up causing accidents, and ultimately it can cause many headaches for an employer. If meetings are held in a home office, making sure that there's a statement and it's understood that the worker needs to keep that area neat and clean to prevent anybody else from potentially getting hurt while they're at the employee's residence. And these remote work policies will definitely help when it comes to WSIB and potential claims and helping clarify whether it is actually on work time or during the course of work, or if it is something that happens outside of. So I mentioned health and safety committees. If the employees are working remotely, is a health and safety committee needed? This is a question that has come up over the last couple of years, and having this in your back pocket would definitely give you some extra credibility. They are still required. If workers are working remotely, it doesn't change the fact that a joint health and safety committee is still needed. There are still health and safety issues, some of them that we've mentioned previously in regards to this, making sure that there's solutions in place and that they are discussed. A health and safety committee's responsibility is to inspect the workplace and make recommendations on how to improve health and safety. They're very much involved when it comes to any hazardous conditions or any incidents that might arise. The role of the Health and Safety Committee is also to raise awareness of any health and safety issues and help communicate them to both the employee and the employer. They're such a valuable resource when it comes to health and safety in the workplace for a variety of different reasons. So some of the different things the different duties that a health and safety committee or a rep might have, including conducting inspections, identifying hazards, having regular meetings, discussing safety concerns, and developing recommendations. So how can the employer actually support the Joint Health and Safety Committee when it's a remote environment. In the workplace, they would provide a meeting room, they would provide time allotted to the members so that they can prepare for the meeting as well as conduct their duties and responsibilities. When you're working remotely, an employer needs to provide resources to the Joint Health and Safety Committee members while they are working remotely as well. They should also help them determine best practices. So we'll get into those in a second. Keeping the Health and Safety Committee members informed of any potential issues, changing policies, pandemic updates, when you're reopening, making sure that the members are kept up to date. They need to encourage regular communication between the committee and leadership team with virtual check-ins. Celebrating health and safety successes, making sure your employees know that identifying hazards is not a sign of failure, but a step towards improvement. And keeping the Health and Safety Committee members' training up to date, including finding ways to have distance learning set up to make sure that they can maintain their certifications where required. So just from a best practice standpoint, the first thing that you can do is make sure that you still schedule your meetings. I know even now with a couple of my clients, we still hold the Joint Health and Safety Committee meetings remotely. We still hold them over Zoom or Teams, Google whenever it is needed. So making sure it's easy to forget to meet with members when you're not in a physical workplace. So whether you meet every 3 months or more, it's a good idea to schedule them out for the entire year so everybody's aware and they can actually be prepared. Make sure all members have the information they need before the meeting. Sending out your health and safety updates and minutes from the previous meeting well in advance. Meeting notes can't be posted when everybody is working remotely, but the Joint Health and Safety Committee members need to be able to share the meeting minutes and the notes with everybody within the organization. And what you could do is you could post them in an employee portal if that is something that actually works. You can also develop a remote workplace self-inspection process. So this is something that you can pass on to the employees and have them as a requirement of part of continuing their work from home. Sending in a regular inspection where they do an actual inspection of their work area in the house. I do have some qualms with this because some people could just inspect it and kind of just mail it in, but photos and videos and things like that can certainly prevent that from actually happening in most cases. If the workplace is closed, on-site inspections, they might not be possible, but employers still need to educate the members on the hazards that could affect remote employees, including musculoskeletal disorders, trips, slips, and falls, and mental health disorders related to remote work. However, if the workplace is open even to a small amount of people, the Joint Health and Safety Committee still has a requirement to inspect the workplace, and one of them must attend the actual physical location of the workplace and conduct that inspection. You can also encourage employee communication. This could be, employees may not feel comfortable discussing certain issues with their supervisors. Communication with a Joint Health and Safety Committee member could be a great way to make sure that these issues are still brought up. Without physical inspections, employees don't have that opportunity to speak to a committee member while they're doing an inspection. Having virtual open door meetings could be a great solution that allows remote employees to talk to their committee about any concerns. And you could also have anonymous email surveys that can be useful to gather employee feedback about more personal issues like mental health. And finally, your last one would be staying certified through virtual Joint Health and Safety Committee training. So regardless of whether the workplace is closed, you still are required by law to maintain a certification if you are a Joint Health and Safety Committee certified member. Health and Safety Committees are required to have a minimum of 1 manager and 1 worker that is certified. The certification years ago used to be you take it once and it would be good for life. Back in 2015, they actually added a 3-year expiry to them. So anybody who took it after 2015 is required to renew it every 3 years. With COVID, a lot of the service providers and trainers had to shut down their physical locations, but they've been able to develop virtual training that allows people to continue to maintain their certification statuses. Making sure these don't lapse is important, because as an employer, if you let it lapse, they have to go through the whole process again, which is a 5-day training. Whereas every 3 years, if you keep it current, you are actually only required to take a 1-day refresher course. So it definitely helps the employer to make sure that these things remain current. And now most training providers are offering a virtual option for this. Distance learning is great because someone can log in from home and make sure that they can take their training. They can log in wherever it is that they are. You know, everybody is logging in today to do this meeting here today. You know, a lot of people, in a lot of cases, you can't really get together. It makes it really difficult when people are all over the place. So the same thing goes for training as well. Some things have to be done in person, but a lot of training is starting to be moved online for employers to understand as well. So there are opportunities to help make sure that everybody maintains their training. So I guess kind of to wrap up here, when should someone call me? So if a worker ends up injured while they're on the clock, it's a good time to call me. I can help out. I can help with WSIB management. I can help with doing proper investigations, or I can provide guidance on making sure that the right steps are being taken in the workplace. If you're looking to develop a telework or remote work policy, I can help with safety considerations that you need to be aware of, or an employer needs to be aware of. If you're trying to make sure that you maintain your joint health and safety committee, whether it's forming it, maintaining it, or even mentoring it, I can be a great resource, including attending meetings when required to make sure that they stay on track. If you need checklists for inspections or incidents or training or anything like that, I can definitely help with stuff like that as well. And any general workplace safety specific questions. You know, I like to try and help people. That's one of the biggest things that I try and do, is I help people. And, you know, I'm lucky enough that I get to make a living helping people, just like many of us do. So if there's questions that come up, I am a great resource for people. So, and then I just wanted to leave my contact info here. And then I do see that there are actually a couple of questions. So I will leave the floor.
I'm going to start first. So just so everybody knows, to be clear, we will be sending out Matt and Doug and Lisa's contact information when this is done. So there will be an email. You don't have to worry about taking notes. Doug, holy crap, thank you so much for all that information. I know for myself, when every time I speak with, whether it's safety person or HR or lawyer, so many new points and thoughts come up that I see my clients falling into all sorts of dangerous situations. From my point of view, one of the things that you brought up that I think is super important is, okay, you've got somebody working from home, and maybe they work from home in the same town as the employer, but maybe they decide to go work in Arizona or in Costa Rica for 6 months. My question that I hadn't thought of asking to the insurance companies is, how long can they stay on the benefit plan if they're going to Costa Rica for 6 months? You know, we mostly have benefit plans that have 60 or 90-day travel insurance, but, you know, do the people have to fall off? There's a new question I have to ask the insurance companies. Another point you brought up that I think about for anybody here who's in the P&C world, and maybe they can hop on and quickly answer, but I would suspect that everybody should talk to their own insurer, is, okay, they're working from home and now they're required to come in for business meetings. Are they insured for that in their car insurance? So many different things. One of the other things you brought up was work from home versus work remotely. I thought that was the same thing. What is the difference between work from home and work remotely? That's a question. That's a question.
That's a question. Okay. So, I mean, remote work ultimately is when you are working whether it's temporary or permanent arrangements, and working from home is specifically working within your homestead. Ultimately, so that would be the kind of the biggest difference. Working remotely is more, you can kind of go to a coffee shop, and if that's where you're working for the day, you're working remotely. If you're working if you're working in a shared space, if you're working like on vacation, that's kind of working remotely in those cases. If it's not your normal homestead, then it would be classified as working remotely.
Which is really interesting, because you speak about people needing to have, a safety audit. How do you do a safety audit of a Starbucks, or how do you do a safety audit of a Mexican resort? So, even more things to think about and put into contracts. My last question, and then we'll get to the other questions that are out there, is just out of curiosity. My assumption is that there are going to be more injuries for people working from home. And I imagine that will lead to higher work safe rates. Have you started seeing any of that yet?
I haven't actually myself specifically come across too many. A lot of my clients have actually brought the majority of their people back, but there are in some cases where they are working from home maybe 1 or 2 days a week or something. And I haven't seen a lot of injuries, but I've heard of horror stories, like even the one I had mentioned in regards to a lady fell down her stairs. And because it was actually deemed that she was actually working during that time, she had gone upstairs to get something. The employer was responsible, even though the lady had a very cluttered top of their stairwell.
That was the Air Canada claim, wasn't it?
Yeah.
Yeah.
So I don't know how much it's going to come up. I have seen a lot more people having to go back into the office, which I think brings up a lot of other issues, because that's more of a hiring side, and I guess the HR side in that sense, because a lot of people just say, well, I'm going to go find someone who will let me work from home. So just a whole other ball game in that one. So
yeah, maybe Lisa and Matt will touch on that later. Lindsay, are there any questions in the chat for Doug?
There is one question, Doug. Do you have a sample checklist that could be provided to myself, Jay, or Blake to distribute to the group?
Yeah, so I can provide something to you guys to send out to everyone. That would be kind of an idea. So
Fabulous. Thanks.
That's awesome. Okay, so we're gonna move it on here. Again, Doug, thank you so much. I've got so many notes that I could keep asking you questions for the next hour, but we don't have that today. So we're gonna move on. And our next speakers are Matthew Wise and Lisa Arthur. Matthew is an employment lawyer with over 20 years of experience acting for both employees and employers. He's a partner at McDonald Sager, LLP, and has been dealing with all aspects of remote work from both his downtown office and from the comfort of his own kitchen table. Lisa is the principal consultant at Larco HR. Lisa has over a decade in the HR field, along with over 25 years of customer and hospitality service and experience. Lisa is also a certified executive and leadership coach. Lisa's main goal is to make an impactful difference. Lisa's varied background, knowledge of HR, best practices, coach-like leadership, and understanding of business operations gives Lisa the expertise to serve as a trusted HR partner who can make that difference. Lisa's belief is that the integration of a long-term HR strategy combined with businesses' objectives, missions, and vision will create a stronger culture of engagement for employees. That culture will ultimately help recruit and retain people for the long run. Today, Matt and Lisa are going to have a live conversation about virtual employees from their similar but different viewpoints. From my point of view, I never really know when to bring in an employment lawyer or when to bring in the HR specialist. I hope this clears things up for me and for all of you. Matt, Lisa, the floor is yours.
Thanks, Jay.
Thanks, Jay. Awesome. So I think I'm just going to start by asking Matthew a few questions, and we're going to get into a bit of a dialogue. Can everybody hear me? Yeah, cool. So thanks. Some of the stuff that Doug talked about kind of crosses over with some of what we talk about, which is great. But but we can touch on that when we get there. So Matt, when we're thinking about key factors that employers should be aware of before allowing employees to work remotely, how does employment standards legislation apply to remote arrangements?
Yeah, well, that's a great question. And first of all, I want to thank everyone for coming today. Thank you, Lisa. Thank you, Jay, and thank you, Doug, for your earlier comments. Yeah, I learned a lot during Doug's comments as well. But to your question, Lisa, this is the most common question that's being answered these days. And the lawyer answer I give is it depends, of course. The general answer, the starting point, the prima facie position is that the employment standards apply where you reside, where you are situate. If you're in your basement in BC, the employment standards in BC would apply. Unfortunately, the courts haven't given us much guidance just yet. This idea of remote working, as we all know, is not something that was the norm pre-COVID. So the majority of, if not all, of employees who were employed pre-COVID, pursuant to a contract or not, it's almost certainly an implied or explicit term of your contract that you are supposed to be working at the premises. So if the office is in BC, you work in BC, BC applies. Now, of course, things have changed. Things are up in the air. As Jay said, I happen to be in Ontario now. For all anyone here knows, I could be in Costa Rica. I've got a blurred background and some white walls, so I could be anywhere. But I am currently an employee in Ontario, and therefore the employment standards rules of Ontario would apply. The general advice or guidance we're getting from the courts these days, or at least from the Employment Standards Office, is if there's a connection to Ontario or you're continuing your work in Ontario, then the Ontario employment standards would apply. For example, I have a situation where I have an Ontario charity. The charity's in Ontario, everything happens in Ontario. One of their employees decided, I want to move to the East Coast. Can I continue working for Ontario charity from my kitchen table in Nova Scotia? Now, of course, the employer could have said no. In this instance, they said yes. But because it was a continuation of this person's work in Ontario, there was no question that the Ontario rules would apply, because this organization was specific only to Ontario. Now, what if this situation was reversed and the employer had offices all throughout Canada and the same employee is moving to the East Coast? Then it becomes a bit more of a live question in terms of which employment standards apply. The good news for most of us on this, with the exception of those calling in from Quebec, is that the employment standard legislation is relatively similar throughout the provinces. The key things we all want to know about is termination, overtime rules, leaves of absences, etc. There's not all that much difference between the provinces, but there are subtle differences, and therefore it is important to know specifically. You can't ask for rulings from the employment standards offices, at least in Ontario. They don't move too quick. They never did. And these days they don't move too quick at all. Lisa, as you know, there's also some significant tax consequences in terms of where and how provincial taxes are applied. I don't think for the purposes of this webinar that we need to get too deep into the tax implications, but it is something that employers should take note of. Do you deduct, if you have an Ontario company and one of the people is working remotely from BC, which provincial taxes do you deduct? So that's a live question. I think I gave a long answer to your short question, Lisa.
Yeah.
So I'll throw it back to you if you have anything to add in that regard about the applicability of employment standards, depending on where the person is actually, where their kitchen table is actually located, for lack of a better way term.
Yeah, I think you nailed it, but that's the biggest question for sure I get from clients is where, what laws and what province laws do we use? And also, like, okay, well, I'm in BC and my person's in Ontario. When it comes to payroll rules, like, what does that mean? Like, how do I pay them? And it's so when it comes, as Matthew said, it was, it's the province where that office is located is where the payroll rules come from. But I'm not a payroll expert. That's just because I've had so many questions on this topic. I've actually, I've come to understand that that's what it is. But I think it's, when I was talking, Matthew and I were talking earlier, it is important to note that there's like nothing really concrete yet, because this is so new, and so things will change. And so as soon as there's like a case, which we'll get into later, where there's like time theft, working remotely, do we then need to change employment standards and
Yeah.
account for those things? So,
And if I could add, again, unfortunately, we don't have perfect clarity from the courts on this issue just yet, but I would think, at least just looking from my notes that I jotted down, might be helpful to list some of the factors that an adjudicator or any decider of the case may look into. The first factor, of course, is where's the work done? Where's that kitchen table and computer located? Is the out of province work incidental to the employment relationship? In other words, is this a permanent thing? Will they be working from BC permanently going forward? Using our example, is the work that's being done in BC, is it Ontario work? Is it servicing Ontario clients, Ontario customers, etc.? That's a consideration. Where is payment made? Where was the contract signed? Where is the employee normally resident? Things like that. Those are the kinds of things they would look into. My gut tells me that the courts aren't going to get very creative with this. They're going to give a basic sort of general guidance that says if the work is continues to be mostly Ontario work, it's Ontario. If it's not, if the person lives in BC and they're doing business throughout all the provinces or primarily in BC, it's going to be BC.
Mm-hmm.
So,
yeah. One of the other questions I get a lot is, and this was earlier in the pandemic, but I imagine that this question probably still will come up is, if an employer is moving to fully remote, partially remote, can I modify the terms of their employment contract? Because, they're living in Vancouver, it's expensive in Vancouver, and now they're moving out to the, a smaller town where we approve them to go. Can we change their employment terms and contracts? So have you ever, what does that look like? I mean, in my opinion, that's like, if there's a fundamental change to someone's contract, it's constructive dismissal, right?
no question.
So, yeah.
If your office is in smack dab in the middle of Vancouver, which, real estate prices are as high as can be, and you move to, I'm not going to disparage any other part of the country, but a more remote part of the country, a more remote part of the country where, $500,000 will get you a much bigger home than it will in Vancouver, and it'll get you a lot more groceries. But the short answer to your question is no. You cannot fundamentally change the terms of someone's employment without adequate notice in any manner that would be to the detriment of the employee. You can do it as long as you give notice, same as everything else. If you have a short-term employee who's under contract with strict termination provisions, and they want to move, give them adequate notice that this will apply until such and such a date, but after such and such a date, your commission is being removed, your car allowance is being removed, for example, et cetera, et cetera, et cetera. Anything can be done with notice, but Lisa is absolutely correct. You can't just cut someone's benefits or perks or salary unilaterally because they choose to work remotely. I have seen arguments made, but I've seen no sort of definitive guidance from the courts, again, on things that I sort of touched on there. If you have a car allowance because you're commuting, and then you move somewhere where you're not commuting because you're working from home, I think the employer would have a good argument that they no longer need to provide the car allowance. And then it becomes a legal question of whether or not the car allowance was a fundamental term of the employment relationship, whether it falls into the definition of wages under the relevant Employment Standards Act, et cetera, et cetera. But I can see, and I've seen these arguments made. Again, I haven't seen what the conclusions are, but I've seen employers say, well, wait a second, if you're moving to a remote part of BC, and we're right in the heart of Vancouver, and we used to pay your parking every day. We're not paying your parking every day, et cetera. So there are ways to do it, but like anything else in employment law, you got to be really, really careful if you're the employer, because any unilateral move downward can expose you. And if the employee wants to make things difficult, they can.
Yeah, that's definitely important to note. And like on that, it's like another thing that employers should be aware of is if you are doing this, like it's not just like the person and their contract and them going remotely, what that looks like, but take a look at all your other policies and procedures, because what does your employee handbook say? I was working with a client who's like, oh yeah, one of the perks of working here is that we provided them with up to $500 for some sort of transportation that was eco-friendly, to as long as they were using that transportation to get to work, which included e-bikes, and they also had a program where they allowed people to purchase electric cars and hybrid vehicles. So it's like that was like, oh, now that we don't have a physical office, do we have to change that, and what other perks can we offer? So it's just being aware of all of it, not just the individual situations. So,
and then the other thing you have to remember from a negotiation standpoint is the employer can always say no. It's a term of your contract that you report to work every single day at our offices. If you want to change that, employee, well, maybe we want to change something too. So there are ways to do it. In my experience, and my certainly suggestion to any of my employer clients is work with them. Try to figure something out. But you got to do what's best for your particular type of business. If you don't care if employees work from home, let them work from home. If you see there's some downside, it might be something you want to work with the employees. I'm sure most people on this call have read certainly a lot of articles out of the United States about how work from home is a huge selling point for companies to attract better talent. And there's all sorts of anecdotal evidence, at least in the United States, and I'm sure here too, of 28-year-old employee applies for a job at company A. Company A says you can work from home 3 days a week. Company B says you can't. Most people are going to choose company A. So it's a consideration employees need to take, because frankly, even though you don't have to, if your competitors are allowing more flexible work arrangements, then you might find that the best talent is looking elsewhere. Mm-hmm. So that's a key thing for sort of a non-legal piece of advice I give to employers, but I think it's important because I think there's some pretty clear evidence. And again, anecdotally, I know from some of the young kids that work in my office, kids mid-20s, but yeah, they tell me, they tell us all the time. I said, yeah, my buddy was looking for a job and they wanted to come to work 5 days a week. So he said, nah, forget it. I can go find another job where they won't make me come to work. And that's important, really important consideration from a business standpoint for all of the employers out there. So absolutely.
That definitely crosses over with battles I have with clients all the time who are really, really resistant to having people work remotely or flexible or anything. It's like, you're not going to attract the best talent, right? Like you're limiting yourself.
Yeah, you'll lose people. As obviously as an employment lawyer, I'm sort of have my ear to the ground on hirings and firings, and people like yourself, Lisa, are mentioning to me all the time that they're losing people. People are complaining that they're losing people, and I say, well, one of the factors is you're making them come to work every day, and the world has changed, whether we like it or not. The world has changed.
Yeah, absolutely. I think it's important that we talk about, that idea of time theft, and it's come up more recently. I had a client who said, this guy spent 2 hours hiding in the bathroom. We want to fire him for time theft. And this was a person who was actually physically, in a location, not working remotely. So, but obviously, it crosses over, I think, a little bit more in the remote scenario where employees are also thinking like, how do I track these people's time, and what's appropriate, what's not? Can I implement like technology that tracks exactly what they're doing and when they're online? And so I don't know. What are your thoughts on that, Matt?
I mean, it's certainly, I'm no expert in.
Am I the only person that sees Matt?
Matt's
lighting up?
frozen.
He's frozen.
Definitely
Matt's
frozen.
frozen.
Sort of,
Okay.
or
Oh,
the,
Oh,
Sorry?
Matt, you froze. You froze.
oh, sorry,
You'll
I'm
have to
just,
start again.
You're good now.
I'm good.
Yeah, we didn't. Yeah, but we didn't hear anything you said. So
Yeah, my computer, I think my internet connection on my computer died. Just let me get my notes back up. Just give me a second. Yeah, I must have had an internet blackout. You guys can still see me? Because
yeah,
you're back. Yes.
yeah.
I can't log on to my computer, so I'm gonna go off the seat of my pants.
All good.
On the issue of time theft, I think what I was saying was, yeah, I mean, there's certainly lots of programs out there that will assist in allowing employers to monitor productivity. I guess I guess it would have to depend upon the industry and the type of business that the person is specifically doing. I'm a partner at a law firm. Most of the people in my office do not come to work every day, and we have not seen a downturn in productivity. We do not track their keystrokes or anything like that. But in my industry, in my company, and I probably in a lot, if people are not doing the job, they'll be exposed sooner than later. Yeah, certainly that was a big issue during the pandemic when things were locked down, is how the heck do I know what they're doing? And my answer is, presumably you give them tasks to do, and if they're not doing their tasks, you'll know. I understand huge multinational corporations, it's easy to hide, but you can't hide forever. But certainly it's the employer's option. I haven't seen any cases that say the employee can't do it. The employer can't do it. Do it meaning track time. The big issue, which we're all dancing around, that's the strictly legal issue, is there is a case out of BC, as some of you may know. It wasn't a court decision. I believe it was a tribunal decision. But essentially, what sorry, let me back up. What happened was this employee, I believe, was a chartered accountant, and she was, among other things, responsible for filling in timesheets. And she was accused of stealing 40 or 50 hours of time, which is, over the course of the pandemic, not a tremendously high number. It's about a week. And she was terminated for cause. And the tribunal supported the employer and determined that she was terminated for cause, thereby disentitling her to any notice or termination pay or severance pay or anything like that. I had a case recently where the woman was accused of about 30 hours of time theft and was fired for cause. This particular woman ended up getting a job a week later, so she had mitigated her damages, so there was no case to pursue. But I was quite prepared, and I had already responded to the lawyer saying, I don't care what the BC tribunal case says. This does not constitute cause at law, which up to and including today, the courts have always said is an incredibly, incredibly high bar to get over. So pre-COVID, I've seen any number of examples of really egregious workplace slacking, for lack of a better term, and the courts have always said, yeah, you probably could have warned her or done something other than end her job with no pay, because that's what a termination for cause is there's no severance pay. You get nothing, and you're going to have a hard time collecting EI. Another way to look at it, depending upon how the question is asked, because the question employers usually ask is, can I fire someone for time theft? And the answer is, of course, you can fire someone for time theft. You can fire someone for whatever reason you want, as long as you give them sufficient notice or payment in lieu of notice. If someone came to me with a fact scenario where they found someone stole a couple dozen hours of time, my recommendation would not be to terminate them for cause. My recommendation would be to pay them as little as possible pursuant to the contract or whatever the requisite employment standards is, and reserve your right to allege cause at a later date. But I wouldn't go down that route because I don't think it's going to work. I haven't seen any case law since that BC decision, but it's coming. It's coming. It almost came with my name on it, but the case. Oh, well, I was ready to argue that one.
We want to see that,
so,
Matt.
Yeah, one day. So it's certainly something to keep an eye on. I don't think small levels of time theft could result in a termination for cause. The one in BC, I think the court or the tribunal put a lot of weight on the fact that the woman did have to fill out timesheets. And not only was she not working, she actually filled out false timesheets. And as an accountant, that allowed the tribunal, made it easier for the tribunal to find that the trust and confidence in this employee had been breached by this, and therefore it constitutes cause because it would be unreasonable for them to to employ someone who they can't trust.
Yeah,
I disagree, but
yeah, it's interesting though. Like, you know, in talking about this, it's like these are like the worst case scenarios, but kind of like working remotely and or working in the workplace. Like realistically, employers should put together a program to train their people better, right? Like when it boils down to it is like, okay, managers need to really be on top of their people. They need to lead remotely just as they would in a workplace. And if you need tips and tools and tricks to do that, then the employer should really build out programs that support their managers to ensure that their people are doing their work, or to, you know, be aware of when they're not. You know, leadership development. There's I forget her name. I'll find it, but there's a woman in Ontario who specifically does this, is train companies on how to lead better remotely. And you know, it's if like Matt said, like those people can't hide for a long time if they are not doing their job. And you know, it's better to go the route of finding that out and, you know, putting people on performance plans, or rather than, you know, putting in a software device that tracks time that could potentially cross over with privacy issues. So yeah, awesome. So that's time theft. What about you know, any sort of like case law that's come up that's in your world that has you know, been different, I guess, Matt, from anything that you've seen in the past? So if there was a case that happened pre-COVID and a similar case that happened remotely, were there any different outcomes that you've noticed at all? Or
certainly there's been some significant changes in what employers need to put into employment agreements since COVID, with respect to layoff clauses, changes in the language of a termination clause as a result of cases that came out in the past couple of years. To answer your question specifically though, Lisa, no, not really. I'm not really aware of anything too significant from the courts, you know, that really speaks to these issues. Again, we're waiting for guidance on how to deal with employees who work in different provinces than where their employer is, and we're also waiting for some guidance on this time theft. I don't think the courts are going to change the general thinking very much, but I'm not sure.
Yeah, no, when it comes to working remotely, I worked really closely with an organization to build out a full kind of remote, flexible work environment. And it's interesting because Doug touched on some of it, which was like having a home office safety checklist, and they built that out. They have offices across Canada, and so they had to account for all the different legislation. So that's something to be aware of. If employers have businesses in different areas and they're rolling out like something specific, like a home office safety checklist, there are, like, for the most part, it's pretty standard across Canada, but There are some nuances that you want to be aware of. So they may need to either blanket cover, making sure they take in all of the different employment legislation into that one safety checklist, or at home safety checklist, or do individual ones. And with this organization, we actually, typically Ontario employment law is like just kind of sets the bar, I find, across Canada. And so we would usually start there, build out the policies that affected, the remote workers, and then kind of check in with the different provinces to see how they differ. Another thing that we created was a working alone agreement. And I'm not sure, Doug, did you touch on that? I'm not, no, there's, so it crosses over with kind of health and safety and just remote working. But, I think it was originally, and correct me if I'm wrong, originally created for people who are on site at, like maybe a security guard at like a building at night or whatever. You need to have like check-in times with people so they know they're okay. But, this might change, but remote workers are also considered working alone if they're working at home. So we actually created a working alone agreement as well for employees to sign off on. And really what it does is it's like a checkpoint. So just like, I think even with, if you're working remotely with Teams, you log in, you're there, but like morning, and then like logging off for the day. It doesn't have to be anything, but to have that kind of process in place to ensure it's there. Yes, Doug, Yoda.
I was just going to kind of add to that.
Yeah.
Some of the things you'd probably have to include in that too is normally in the workplace, if you send someone on site and they're alone, there's certain things they're not allowed to be doing, like working from heights or something like that. So you'd probably have to also incorporate that to remind your workers that even though you're at home, you can't go and say climb up a ladder and fix something while you're working from home and maybe you're on a break or whatever sort of thing. Just, it'd probably be added into a working alone procedure sort of thing as well too, right? So
Yeah.
And if it hasn't been mentioned, I mean, I think it ought to go without saying that if the employer is implementing a system whereby certain employees are working from home or remotely, like anything else, always best to have something in writing speaking to the expectations that the employer has. Frankly, circling back to the issue of time theft, well, I still don't think it would be enough to get you over the bar, but I could certainly foresee certain circumstances where a provision in a work from home agreement that speaks to the issue of time theft and how it is a serious consequence and it may lead to a termination for cause could, in the right fact situation, really give the employer a good argument for cause. So it's not definitive, but certainly having a provision in the work from home agreement that speaks to that issue would help the employer if they do encounter, an egregious case of time theft and they're debating whether or not to allege cause. Certainly much easier argument if there's provision in the agreement than if there isn't.
Yeah. More is better sometimes. Sometimes not. You have to be able to uphold it on the employer side though too, right? Do you have the people in place to make sure that they're ensuring people are doing that, right? Or you could be conflicting with your own policies internally.
Yeah,
so that's come up as well, right? So
yeah, for sure. Sorry, I'm not sure how long we've been talking, Jay. I mean, we can certainly keep going. I have the bit of a disadvantage that my internet seems to have crashed out on me, so I don't have access to any of my notes, but we can talk about, we had a couple more topics, Lisa, on our agenda, but I'm not sure how we're doing on time, Jay.
You know what? I didn't set the stopwatch, and because you guys have combined your conversation, you've gone from, half hour each to a combined conversation. So we're still way ahead of the overall 2 hours that we had planned for today. So if you've got a couple more topics, yeah, please, we do have the scheduled time. Okay.
Okay, Lisa, what was next on our, we want to talk a little bit about the right to disconnect and how it works in conjunction with remote work.
Yeah, that's right. Yeah.
Yeah, I mean, I'm not sure. I mean, certainly the people in Ontario are probably more aware of this new legislation that's been brought in that pertains to employers with more than 25 employees. And it does give employees a lot more leeway to not respond to emails at 2 a.m. from their boss. To take one extreme example, I have heard very, very mixed results in practice on both sides, from employees and employers. Unfortunately, a lot of the employers I've spoken with seem to think very negatively about this legislation and seem to think that if I'm paying you, you should be available anytime. The legislation disagrees with that, but employers, at least in my experience, are not terribly happy when an employee plays that card, for a lack of a better term. There is provision in the Ontario statute that says someone should not be punished for trying to assert their rights, or there should be no reprisal for that. But as we all know, it's not hard to fire someone and pay them some notice, and then just say, we didn't fire them because they spoke up, we just simply fired them. That's a bit of a dangerous game. Again, there hasn't been too many decided cases on this issue. My concern with it always has been more from the management side, and maybe Lisa, you can speak to this, is the employees I've spoken with are terrified to raise it, notwithstanding that the statute is there. Facts on the ground are still that. Most of the employees that I've at least consulted with on this issue have been too afraid to assert their rights, and have not wanted me to write a lawyer's letter on my letterhead because of the impact that may have on the workplace. This runs entirely counter to the purpose of the legislation, but at the end of the day, the practicality is I have seen certain hiccups in its implementation. I guess as a society, we're not quite there. I know in Europe it's been much more successful, but I think perhaps they have a different work-life philosophy in Europe than we do here, for better or worse. And so I think it's a tough one. I think a brave employee is going to make a lot of money against a boss who is acting unreasonably and contrary to the act. And I've seen really obnoxious dialogue coming from employers to employees who have attempted to assert their rights in this regard. So I personally think it's a bit of a mess. I'm happy it's there. Some employers are going to get slapped by the courts pretty hard once a nice fact pattern is put before a judge. I suspect the judge is going to come down hard on an employer who is cavalier towards these issues being raised by their employees. The legislation was put there for a reason, and the judges, I think, are going to be not too pleased. But I'm not aware of I'm not aware of a big slam dunk that an employee had just yet. But it's out there. It's out there. I don't know how familiar people are in Ontario. I don't believe there's similar legislation in BC or elsewhere, but I think it's coming.
Yeah, I think, yeah. So when we're looking into it, I think it's only Ontario that has the
So far.
right to disconnect, and maybe they're using Ontario to figure out those kinks. But I imagine that this will also come across Canada. So
Yeah.
and it is for employers that have 25 or more people, and it's basically a policy that is mandatory for employers to roll out, to allowing to ensuring that their employees are, free from work and not required to work after working hours, because it's just so easy when you're working remotely. And it's interesting because, there's lots of thoughts on that, but like, when it comes down to people who are working remotely, it's quite often it's like they do stuff here, they, take a break, but they're okay to log in later and do some work. So
Yeah,
it's interesting.
I've seen in my personal life, a good friend of mine is really getting taken advantage of by her boss. And I've given her advice and she's like, no, I'm not saying that to my boss. He'll fire me. So, but you're right, Lisa. The reality is when you're working from home, yeah, like, you know, you may take a longer lunch, but then you may work till 9 o'clock. And it goes back to my comment from earlier is, if your employees aren't getting your work done, they can't hide forever. They'll be exposed eventually. And if you're running a good business, you'll know when your employees are not pulling their weight, for a lack of a better term. And sure, it's much easier to hide from home. Certainly at the beginning of the pandemic, it was pretty easy. But I think it's getting harder and harder. I think employers are learning more each and every day. And anyways, that's where we stand.
For sure.
Matt,
do you deal with any?
If I may here, just for a quick second, I think about what you're saying, and I think about what Doug was saying earlier when you talk about, Doug talked about the work hours, and we all know that there are employees who will take that longer lunch or will go swimming or whatever. And so they'll extend their work day, and then you've got the right not to contact what are the work hours if people are extending their days between 5 in the morning and 11 o'clock at night. Becomes a really high bar.
Sorry, I turned off my screen. I'm listening. I'm going to try to plug in my internet because I desperately need my notes. So I'm walking around my house to try to fix my internet, but I'm engaged in this conversation.
Okay, so while Matt's figuring out his computer,
we could ask some questions.
Yeah, I've got, well, do you want to ask questions in the chat and then I'll come to mine for a bit later?
Yeah, there's a whole bunch in the chat. So let's go through some of these ones. So one of the first questions actually from Doug, how much notice would be required for that? Is it dependent on the length of the employment? So to your comment, Lisa, where we were talking about an employee living in Midtown Vancouver and then, you know, moving to a more remote location and the employer potentially wanting to make an adjustment to salary or something like that. How much notice would be needed to that employee if a change was to be made?
Yeah, so I think when it comes to like a fundamental contract change, the employee has to sign off on it. So if someone's moving remotely and you're like, okay, we want to pay them less, I'm not sure how many people would actually sign off on that. But to be honest, there's people who would take less money to work remotely. So it doesn't build a great culture. I wouldn't recommend it at all. And if they don't sign off on some of these fundamental contract changes, like Matt and I were talking about, like it would be considered constructive dismissal, because if then they don't accept it and they move away and then we change things on them and it's a fundamental change to their contract and they complain, it's constructive dismissal. So that's a whole other
To me, the interesting part of that question comes from, did the employer assign the change to working remotely, or did the employee request the change to working remotely? If the employer signed it, then I could see that changing a contract would be wrong. But if the employee requests it, then that might open, and I'm not stating this, I'm essentially asking if that would open the opportunity to change some contract provisions.
Yeah, it's interesting there. Like one of the policies I rolled out with an organization was they were open to flexibility and people working remotely from home or wherever, but they actually assigned themselves as they called themselves an in-office first organization. And so if you chose to work from home, that was up to you, but we won't have to provide you with any additional sort of equipment that you need to do your job. So it kind of like removes the liability from the organization to having to figure out how to ship desks and chairs and equipment and all that. And it's like, that's your choice. So you do that, that's you. But then it came across, like, I think Doug talked about it. It's like, where does it then cross the line if someone needs like an ergonomic chair? So it's like, okay, then the employer is still responsible for providing that, I feel. But yeah, so I think it kind of rolls back to, and again, it will hold up in court, will it not? I don't know, but having that strong like policy, strong procedures, strong documentation internally to be able to support whatever it is that you're doing. I don't know if Matt, you want to touch on anything else there?
Matt, are you fully back now?
He looks frozen.
He's frozen.
He's not fully back. Okay, Linz, do you want to go to the next
I'll
question?
go to the next question. So the next question is, if an employee had been based out of an office and then is demanding to work from home, does that reopen the employment contract?
Does it reopen the employment contract? So they're demanding to work. So, yeah, I mean, this comes up a lot like that. I mean, if they're working in the office and they want to work remotely, it's like, well, that's not where you're working from. So, you know, it's your contract is based from working as per your original contract. And, you know, the employee would essentially be resigning, right? If they're, you know, if they're required to come into the office, that's what the employment contract states. That's what the entire organization is doing. And they say they want to work from home, and the employer says, I'm sorry, we don't have that arrangement right now because we don't have all the things in place to support that. And the person just doesn't come in. It's kind of like if an employee just doesn't come to work. It's like at what point is this going down a bad path? And of course, you have to be reasonable and look at, you know, do we end up terminating this person without cause because they're not complying, or are they resigning? Is there job abandonment here? So there's a couple of different, it kind of depends on the situation, but you would kind of examine all those paths. There's like on the flip side of that, I think employers, like for the most part, most people have gotten over this hurdle, but I am working with a couple clients right now where they have been remote and then now they're asking people to come back in. And that's been a little bit foggy. So, you know, my recommendation is like, you just have to give them a bit of notice. So what reasonable notice, it's kind of like anything. What's reasonable? What makes sense? Like, you can't say like, you've been working remotely for 3 years, you know, 3 days from now, we want you to be in the office 5 days a week, full time. It's that doesn't allow people to be able to like adjust and prepare and figure out, you know, maybe they got rid of a car, right? So it really comes down to, if there's no policies, procedures, and you know what to do in place. It's really being like considerate of your people to be like, okay, this is a change. We can ask people to do that, and if they decline, then ultimately it's like, you know, you can end that employment relationship if it's fundamental for them to come in and the rest of the people are. But it's whatever's reasonable is always, and that's a gray area, and that's why I exist and Matt exists, right? We work in that gray area.
Hopefully help clear up some of that gray area.
Yeah, it's so, yeah.
Thanks for that, Lisa.
Any
Yep.
more in the chat?
There's a whole bunch. So the next one's from Gavin, and Gavin, I'm going to get you to chime in if I say this incorrectly or if you want to add to it. So Gavin's comment and question, I think it is some small group insurers charge PST on health premiums according to the employer-employee premium split, such as Canada Life. If an employer is in Ontario and the employer's portion attracts 8% PST, and if the employee is in BC, the employee's portion of premium attracts 0% PST, whereas carriers like Manulife or Sun will charge PST on the entire premium based on where the employee resides, i.e. if there's an employee in BC, there is $0 PST, even if an employer is paying part of the premium. I've had a situation recently with a TPA that applies PST based on who's paying, where an Ontario employer got some VC. Gavin, what's VC?
Venture capital.
Venture capital
Funding. Yeah.
Thank you. Venture capital funding, and went on a hiring spree of remote virtual staff in other provinces. And the employer said the province of employment equals the province of residence. And they gave the employees tax forms to this extent when hired. The TPA challenged this and said that business address in Ontario, so they will keep the province of employment as Ontario. They've since changed course on this decision. What is the best practice for determining province of employment? The tax forms, the employee signed, physical address, whatever the employer tells us. If we get this wrong, the implication is a client and their employees could be charged the incorrect PST.
Yeah, so I've just kind of gotten out of this, but I was in the middle of the company saying, our person in BC, their province of employment is BC, we shouldn't be paying PST on that entire premium. Whereas the TPA was kind of billing like Canada Life bills, where, you know, their one office in the country is in Toronto. And so they were in kind of this pissing match of no, we're telling you where our employees work, and the TPA say, well, what's your address in BC? What's your address in Nova Scotia? What's your address in Alberta? And so we were in this for months. Like this took a long time to figure out. And so, some carriers, it's just up to the employer on an honor system to report province of employment, province of residence. And I think what I've seen most is the carrier just take the client's word for it. And that's on them if they get it wrong. But in this case, it's the first time I've ever seen it. This TPA took a hard stance. What's the physical address? And I kind of questioned, should the TPA really be stepping in here and taking a hard line? Like, I felt like this is more of a legal issue, and that the client should get counsel on what the right answer. And I'm in the middle because I don't want to say a word over what should happen here either. So yeah, the session today was really timely for me, having just kind of come out of this. But it did come back to, what tax forms did you have people sign when they work for you? And so, I've just haven't been this deep in the thick of the weeds of something like this in the past. So I feel like we're just going to see more and more and more and more of this, especially with a carrier that's splitting up PST based on employer-employee premium, because there's a number of them out there, and I think we're going to see more of them. So anyway, if any insights here would be great.
Yeah, that's a fully loaded question, and for sure that kind of touches on everything. I don't even know if like I would be the right person to ask that question to, because it crosses over on so many different areas, especially like payroll and tax. But when Matthew and I were chatting before, earlier this week, I said, like, I was asking him, like, because he's in Ontario and BC, like he's like, it's not defined yet. And I think Matt said that at the beginning, is like, until these situations come up, there's actually, I think, like, everybody's like, I'm not sure. And so they're like, it takes until a company, makes a hard stance on something, and then someone challenges them, and then they actually start, looking into that, and how do we deal with this? So, I mean, I get a more simple, question similar to that I get asked is like, I'm in BC, I work, companies in BC, my employee works in Nova Scotia, and, there's family days fall on different days in the province. So, if you're working in Nova Scotia, are you taking the Nova Scotia family day, or are you taking the BC family day, right? It's like, there's nowhere you can go to like find that answer. It's like, what's reasonable? Like, if you have a family and you live in Nova Scotia, you're probably gonna take family day off in Nova Scotia, right? And maybe you'll work in BC, but again, or do you get both off? Who knows, depending on your employer. But that's a really tough question for me to answer, and I don't think that's my specialty. And unfortunately, Matt's not been able to connect back in. So
let me just add to this topic. I think of equal or maybe more relevance to benefit plans while Matt's trying to do things. I see Matt's in here again. I don't know if he's able to communicate yet. The thing that you guys made me think about is, okay, so let's say I've got a client whose head office is in Alberta, super low income tax rate, and the employee moves to Nova Scotia, super high income tax rate. One of you had said that, so we're going to run payroll based on Alberta standards. And I think if the employee moved out to Nova Scotia, official change of residence, they're going to end up being taxed Nova Scotia. That person is going to owe extra money at the end of the year. Is the employer liable to make sure that the employee knows that and creates appropriate savings for it? Or can that come back to bite the employer because they didn't inform the employee?
Yeah, that's a great question. I did read in researching for this, I did read somewhere that it gets figured out if there's any discrepancies, but who does that fall on, right? So it's like, if you overcharge, you're going to get a refund. Who gets the refund, right? Like, yeah, I don't know. So
the other thing that I think also applies to benefit plans is we take jurisdictions that have pharmacare, BC, Manitoba, Ontario, for instance, where we're paying lower stop loss and some lower benefit costs because those services are there. If the employee officially moves, theoretically, the insurance company to a non-pharmacare province, for instance, theoretically, the insurance company might just charge more for the stop loss. But what happens if the employee doesn't officially state on their insurance application that they're living in that non-pharmacare province, but they're claiming in that non-pharmacare province? Is this a question that we have to ask our insurers, and we have to make sure that we correctly inform our employers that they must make sure that the employee has the correct address in the correct province? And this isn't actually a question for you, it's just a thought that I now need to bring to my insurers when I hear people moving to other jurisdictions. And you know, out here we might have a 7% stop loss, and Alberta might have a 17% stop loss. This is going to affect the client in other ways that we hadn't previously thought about. Matt, it looks like you're back.
I am, but I still don't have Wi-Fi. But
Okay,
I'm back.
so-
Sorry, my internet's been going in and out the entire time, so I apologize. It's still not working. So I'm on 5G, but I'm back. Sorry, guys. I should add that one of the downsides of work from home is sometimes you run into technical issues that preclude you from doing your job. So
Yeah,
Exactly.
absolutely.
I think at this time, we're pushing 10:30 here. We should probably end the conversation between the two of you, which, even though it was fabulous, and we should you know, maybe spend just another 5 minutes on some remaining questions. Lindsay, do you want to ask maybe one more chat? And I see Anthony has a hand up. We can give Anthony the opportunity after one more chat. What do you think?
Yeah, that's great. There's two that hopefully I can ask. And just before I ask them, Matt, this is being recorded. Gavin had a really good question that I think he wanted you to chime in on. So maybe even if you could take a look at his question after the fact and chime in, I think he'd appreciate it. So the question is from Rick. In the case of time theft, is it an option for the employer to require that the employee return to the office full time if they discover this?
Matt, you're muted. Matt.
Matt, you're muted.
man, it depends entirely on what the contract says. Certainly, I would say that the employer always had the option to require the person to return to work, as that is the prima facie position of the terms of the employment. If you change the terms of employment and there's a contract that says they can work from home, unless you give them sufficient notice that they can't work from home, then you need to follow the terms of the contract. Certainly, if there was a situation where an employee was not doing their job from home for any number of reasons, whether it's time theft or anything else, the employer would certainly be within their right to give them performance eval and give them a written warning that from our end, you're not doing your job, you're not pulling your weight. We're going to reassess in a month, and if things don't change, then we can consider our options, which could include forcing you to return to work or termination. So I think it can be done. I mean, until the de facto position is that employees can work wherever they want, the position is you work from the office.
Right.
Unless you have a contract that specifically says otherwise.
Okay, thank you very much. The last one through the chat is summer's here and it seems many are working at their cottages or while on vacation while claiming to be full-time. How do you police this?
I mean, you gotta, some employers let you though, like it really comes down to the employee-employee relationship and the trust to do the job. So it's if you want to police it, you don't let them do it. But if you let it happen, then you have to let it happen and just have measurements in place to be able to deal with that. And again, it boils down to, is the person doing their job? So, and it also really truly depends on the type of work that they're doing. So if, I mean, I know there's situations right now where, there's people working in call centers and, they're attached to a phone. So like, that's pretty easy to monitor because you can see if they're online or not. But you know, if people need to attend meetings and deliver on work and they're doing that, then it's a matter of, do we trust our employees to get the work done? And, you know,
Yeah, I completely agree. I really think it has to be case by case, depending on the issue, depending on the person, and your level of trust with them. I'm back.
right back.
But Matt, you talk about case by case, depending on your level of the person. As he's still here.
I'm here. I'm
but
here.
You have to treat people equitably in how we treat our employees. Do you not? And could one person complain that you treated somebody a way that you didn't treat them?
See, I hear that argument all the time, and it rarely gets much resonance once it gets to a legal argument. It's more of a management question. Yeah, if you've got one person who works from home and everyone else is forced into the office, you're going to have HR issues. There's no question. Can you make exceptions? Sure, you can. Legally, you can. And as far as the nature of the person and the type of the work, that's what I mean by fact specific. Some people you just know where they're going to work 18 hours a day, whether they're in your office or Thailand or wherever else. Other people you have reason to be suspect of. I wouldn't put too much weight on that when making the decision as to how to proceed. I think it's more, what is the nature of the work? Can it be done without any noticeable downturn from a deck of a cottage as opposed to an office in downtown Vancouver or Toronto or wherever? But it is the employer's option. If the employer doesn't care, go for it. Make your employee happy. And if there's no indication that there's going to be a productivity issue, then don't do it. Then go ahead and do it. I mean, if you're not concerned, then you can do it. But I like happy employees myself as an employer of people. My assistant spends a ton of time at her cottage. My clerk, I should say, spends a ton of time at her cottage during the summer. And if she's not working, I'll know immediately. But she's always working. So I say, do whatever you want. Work from a deck. Look at the lake while you're working. It's much better than looking at the Gardiner Expressway. To those in Ontario. Yeah, that's my view on it. I don't know from an HR perspective, Lisa, if you take a different position, but
no, it's more like it really leads back to, like, does the company allow it? You know, who are you as a manager? Who's the person doing the job? And you know, can you trust them? So ultimately, you'd hope that employers just put trust in people that they get the work done. Mm-hmm. And you'll find out when they don't, right? So
I think it's refreshing to hear these viewpoints because even though, you know, I have a bit of old school in me, the reality is I think we all just have to put our big boy and big girl pants on and just recognize that people are, you know, doing the big brother or having the big brother approach to whether somebody's working hard or not working hard. I mean, I think that ship sailed a while ago now. And
I completely agree. As someone with a 5 in front of my age, I know that there's a lot of people from earlier generations who really are thinking completely differently, for better or worse. And it goes back to my earlier comment about you got to attract talent. And if your competitor is letting people work from home, you may find yourself not getting the top dog at the end of the day. It's a balancing act, and it's changing every single day. We'll see.
Sounds like dealing with humans.
And all the various, it's all the
occupational hazard. Occupational hazard.
Let's give the final question of the day to Anthony. He's had his hand up for a while, and
well, I could have taken my hand down, and as the first person to have ever taken parental leave at my company, and they were none too happy a long time ago, and let that be known when I left the company. You know, we're lucky. We get to pretty much, a lot of us do our own hours, but maybe if someone had a cottage and then I could take all summer off and then have my 4 weeks holidays, but I've never had to worry about. So I'm, you know, it was my question, but I was going to just mention about Gavin. I always thought it was just province of residence. If the province of residence, you add the appropriate taxes. And I don't know why the TPA is making such a big thing about it, but that's it for me.
Well, it's because they split the premiums. So some carriers will split a premium on a bill between the employer's portion and the employee's portion. And it really depends on who you work with. Some carriers do that as normal. Some carriers won't do that on a bill. They're just giving you a lump premium, and then it's up to the company to then split it all out and report to payroll after the fact.
And Canada Life is useless at that. Come on, they can't do it properly, but they try and do it. There's no doubt. But it is province of residence, and as was said, if you're being taxed in Ontario, but your province of residence is Alberta or Nova Scotia, come your T4 time, your tax filing, you'll be assessed in your province. So, yeah, there's always holes.
Well, it's not so much the taxability; it's more the PST that.
No, yep, no, I get it, Gavin, and like me, you have a bad habit, which is my bad habit of getting in the middle of everyone's problems. Go to your accountant.
Guilty.
Not my problem. Go to your accountant and let him make the decision. But I know we're accountants, we're lawyers, we're HR experts and everything.
And that was the whole point, and that's a really good point, Anthony, to finish on today. That's the whole point of today, is that to our clients, we are everything. Most of our clients, most of us deal with small business owners. They don't have somebody like Matt or Lisa or Doug who they can call as a consultant. They don't have somebody who's on their payroll, and they need to know that they need to have these people on, because really, you know, I've been doing this for over 20 years. And I just have a whole list of questions that I could just continue to ask these guys based on what they've said today. And the big thing that came from today is that as that general purpose person that we have become in the group benefit industry, we need to have those eyes and thought processes for, oh, did our client just say something that could get them in trouble with an employee, B, a court, or C, with an insurance company? And that's when we have to go to our insurance company and our knowledge base, and those of us with CGIB membership, we go out there and we ask those questions. So, you know, before I hand over to Blake to close, I do really want to express my appreciation to Doug and Lisa and Matt. Like, that was an incredibly good use of my time, hopefully everybody's time today. So thank you so much for helping us.
Blake, before you close off, Cheryl had a very good question, and Matt, I just want to catch you before you go. Is there any way that you guys can provide some general employment contract wording that can be used to accommodate the new workplace geographic challenges? Or Lisa, would either of you have wording to that regard?
To me, that sounds like a consulting contract.
Thank you. All right.
All right. Well, thanks very much, everybody. And just to the speakers, as everybody knows, these events are free. And so we've been so lucky to get speakers to donate their time to help make our industry better. So just thank you very much from all of us for donating your time today to speak to us and hopefully improve the group benefit world as a whole. And we really are the first line underwriters. So a lot of times you'll have an employer call you up and say, hey, you need to remove this person. I'm terminating them for cause. And you have to think, whoa, maybe we really need to bring in someone before we remove long-term disability or some key benefits that they'd be entitled to. And it's certainly not our job to be advising our clients on how to do that. It's our job to say, hey, I know this guy, Matthew, you should really have a call with him before we remove those benefits. So if you don't have someone like that in your arsenal, I certainly think that you should be looking at connecting with one of these three speakers today and putting them in your arsenal. And then a big thank you as well to BBD, CGIB, and the Benefits Trust, because Jay Lindsay and I can't grow kind of our mailing list without the great support we've gotten from all three of those organizations, where BBD and Benefits Trust, everything we host, they send a big blast out to all of their advisors, and that's really helped us get this off the ground. And just a big thank you to Lindsay and Jay as well. because it's a team of 3 and there's a fair bit of work that goes in. And so just a big thank you to them. And our next session will be a Q&A session in the fall. And so stay tuned to your inbox for that one. And we'll leave it there. So thank you very much, everybody.
Thank you
Thanks.
so much, everybody.
Like, thanks,
Thank
guys.
you, everyone. Really